Yo, this week is Floyd Shivambu week. It's Dear Brother Floyd Shivambu week. It's a Bushiri type of a week. I can't help it. I've got an episode on Elon Musk that I'm trying to put out, but the Shivambu content has just been taking precedence. Floyd Shivambu is now facing a potential legal action from Nhlamulo Ndhlela for his remarks on ENCA. He's received a letter of demand from the law firm representing Nhlamulo. In addition to that letter of demand, Nhlamulo went to Lancet Laboratories. He did a drug test. He tried to exempt himself and to remove himself from any insinuations, allegations, innuendos that he's smoking that good stuff, the powder, the baby powder of the nose. He's like, I'm not there. I'm not involved. As Shakespeare said in A Midsummer Night's Dream, South Africa is a movie. We live in a drama, a series. Every day, you will be shocked by something new. We've even forgotten what shocked us 2 weeks ago. Next week, there'll be something new. I don't know how Shakespeare could see the future of South Africa in A Midsummer Night's Dream. And you can see that the drama is continuing. The drama of this Maibuye Africa party, Mkhonto weSizwe party, there's Kwazing, there's Maibuye ring, it's really a tabloid of sorts. But firstly, that wasn't Shakespeare who said that. That was actually Mcebo Dlamini. In this video, I'm not going to look at the soap opera that this is becoming actually. I'm not going to deal with that. In this video, I'm actually going to look at the legal issues. I'm going to look at the details of the letter, and I'm also going to explain defamation law in South Africa, partly so that you have an understanding of it, and also partly so that you don't find yourself having to pay 500,000 words over some characters on X, on Twitter, or for some words in a podcast, or on your TikTok or Instagram Live. Some celebrities, some politicians, some movements, some organizations will take these things personally and they'll come looking for you. So we're going to look at the substantive issues of law pertaining to defamation, pertaining to what is permissible and what is not permissible. So let's start with the letter from Ndou attorneys on behalf of their client. The letter reads as follows. Letter of demand on behalf of Mr. Nhlamulo Ndhlela for the withdrawal of defamatory allegations, public apology, and retraction. Dear Mr. Shivambu, we act on behalf of our client, Mr. Nhlamulo Ndhlela, regarding false, defamatory, and malicious allegations you made against him during an interview broadcast on ENCA on the 23rd of June 2025 at approximately 4:15. Not 4:30. Not 4:10 actually. It was 4:10 in Luyawa. No. 4:15. It's moved up now. It was 4:10. Now it's 4:15. Emini, not exeni. Anyway, let me refocus. Let me get serious. They say during the interview you made the following allegations.
That report came with him and it was given to him by the people I refer to as scoundrels.
Do you know who they are, by the way? I'm just curious.
It's different people there. That includes an imbecile, a fool called Nhlamulo Ndhlela, one of the foolish leaders of Mkhonto weSizwe who unfortunately represents the people there. He's always on drugs and always high on alcohol in terms of how he deals with issues. That is what we're dealing with every day. And he will even take pride that he is going to tell lies to President Zuma about him. And of course, he will use the otherwise very gullible and directionless daughter of President Zuma. Who of course has got first front row access to President Zuma by virtue of being the daughter. So that is basically what we're dealing with. And of course, Nhlamulo was working with this
druggie on social.
I didn't say that. I didn't say she's a druggie. I said there are people who take drugs, which is true, and insult me on social media at night, and which is a fact in terms of what I say.
The letter goes on. Your statements specifically allege the following: that our client is always on drugs, that our client is always high on alcohol, that our client is a liar who takes pride in telling lies to President Zuma. These allegations, broadcast on a national television platform with significant audience, they were amplified through social media and other channels. The statements were made with reckless disregard for their truthfulness. Your failure to verify the veracity of these claims constitutes a deliberate or negligent violation of our client's rights under South African law including the common law of defamation, and his constitutional rights to dignity and reputation under sections 10 and 16 of the Constitution of the Republic of South Africa. Your actions have infringed our client's rights to dignity and a good name, and we are fully prepared to enforce these rights through judicial process if necessary. We hereby demand, on behalf of our client, that you comply with the following within 48 hours of receipt of this letter. Withdrawal and retraction of the statements. You shall issue a clear, unequivocal, and public retraction of the defamatory statements made against our client during the ENCA interview. This retraction must be published on your X account and pinned for a minimum period of 7 days to ensure maximum visibility. The retraction must explicitly state that the allegations were false, without foundation, and that you regret making them. The proposed retraction wording. The wording of the retraction and apology shall read: on June 23, 2025, during an ENCA interview, I made statements alleging that Mr. Nhlamulo Ndhlela is always high on drugs and alcohol and takes pride in telling lies to President Zuma. I hereby retract these statements in their entirety. I can confirm that the statements were false and without bias, and sincerely apologize to Mr. Ndhlela for any harm caused. You shall issue a sincere and unconditional public apology to our client, acknowledging the harm caused by his statements. This apology must be issued in the same X post as the retraction and published within the stipulated 48-hour period. You shall contact ENCA and request that they broadcast a correction or clarification during the same program or comparable time slot, stating that your statements against our client were untrue and regrettable. You must provide written evidence of this request to our offices at the email address provided. So Floyd has a serious deadline, and he could face litigation if he does not retract the statement which he has made, and the deadline is today. It's today. So what is he facing, and what is the issue? This pertains to defamation. The statements made by Floyd Shivambu using the reasonable person standard are indeed defamatory. Accusing someone of always being on drugs, always being drunk, someone who is a member of parliament, definitely that is defamatory. It is in the terrain of defamation. So let me break down defamation and where it comes from. Defamation is part of the law of dilict. The purpose of law, and in particular private law, is to regulate the relations between individuals in a community. Public law, on the contrast, governs the relationship between the state and its citizens or among different state institutions. So the law of dilict determines the circumstances in which a person is obliged to bear the damage which he has caused another. And that law of dilict belongs to part of private law known as the law of obligations. So now you know what law of dilict is, right? The fundamental principle in law is that damage or harm rests where it falls. That is, each person must bear the damage that he suffers. However, damage does not always rest where it falls. So like if you break a window, it's your baby, right? You broke it. But if someone else breaks the window, then it's their baby because they broke it. Basically, that's what we're saying. They are legally recognized instances in which the burden of damage is shifted from one individual to another, with the result that the latter incurs an obligation to bear the damage or to provide compensation for it. A dilict is defined as the act of a person that in a wrongful and culpable way causes harm to another. And then you need all 5 elements to trigger the delictual claim. That is an act, wrongfulness, fault, causation, and harm. All 5 elements must be present for that to be considered to be a dilict. So, having said that, let's now talk about dignity. You need to appreciate that you have a right to your dignity and your pharma, right? What are we talking about when we say pharma? A person's pharma or good name is the respect and status that that person enjoys in society. I can't just come and say, you love baby oil, you love Hosh Karmaimas, you love hanging out with Sean Combs, aka the Diddler, formerly known as Diddy. I can't just come and say those type of things, because those things could be damaging to the respect and status that you enjoy in society. Any action which has the effect of reducing a person's status in the community infringes his pharma and is in principle an injury and damage to him. So defamation is the intentional infringement of another person's right to his good name. Defamation is the wrongful, intentional publication of words or behavior concerning another person which has the effect of injuring his status, good name, or reputation. At common law, the elements of a delict of defamation are the following: wrongful, intentional publication of a defamatory statement concerning the plaintiff, right? It is not an element of the delict in common law that the statement be false. I'm going to talk a little bit about this further. It is not an element of the delict in common law that the statement be false. Once a plaintiff establishes that the defendant has published a defamatory statement concerning the plaintiff, it is presumed that the publication was both unlawful and intentional. Therefore, a defendant who wishes to avoid liability for defamation must then raise a defense which rebuts unlawfulness or intention. So if I say you were attending diddler parties, if I say you were the one rubbing the baby oil on all of, the gluteus maximus muscles which were, explored, that is something that I will have to prove as the person defaming. Even if you come to the courts and say, this guy is saying I went to diddler parties, right? You don't have necessarily as the plaintiff to prove that it's false. The burden actually rests with me, the person who made and published the statement. All right. So there's an interesting case with similar facts to the Nhlamulo and Floyd matter. And that is a constitutional court case of Fred Khumalo and others, Sunday World versus Bantu Holomisa, the leader of the UDM party and the current Deputy Minister of Finance. Here are the facts that you need to be aware of. At some point, Bantu Holomisa was suing the applicants, right? Fred Khumalo and others who were responsible for the publication of a newspaper, the Sunday World. And in that publication, they had made a defamatory statement in one of their articles. In the article, it was stated, amongst other things, that Bantu Holomisa was involved in a gang of bank robbers. A gang of bank robbers. Imagine that. There you are minding your business, Jiggy Sunday World, boom. You are part of a gang of bank robbers. Not only that he was under police investigation for his involvement. So as far as headlines go, I think that one is up there with one of the most scandalous and most salacious headlines. I think the other contender for headline of the decade or one of the historic headlines is that one which said, I don't know if you saw it, where it said Robert Mugabe and Jacob Zuma live in Dubai as neighbors. Not only do they live in Dubai, which is in and of itself a spicy level of detail in terms of like these two African politicians, they cobbled up whatever monies they could cobble up from whatever corruption they're being accused of. And they were like, let's buy some properties in Dubai, yeah? And then not only that, can we be neighbors? Maybe we'll play some chess, Robert Mugabe, Jacob Zuma, neighbors in Dubai. We've seen a lot in the media. We really have. We've seen... I can't imagine what precipitated that editorial decision. They were like, you know what? People don't like Jacob Zuma and they don't like Robert Mugabe. Let's put them together in Dubai. Let's put them together in Dubai. Back to the case that we're discussing. So Fred Khumalo and others went to the Constitutional Court and argued that the common law of defamation as developed by the courts was inconsistent with the Constitution. In particular, they raised the question whether, to the extent that the law of defamation does not require a plaintiff in a defamation action to plead that the defamatory statement is false in any circumstances, the law limits unjustifiably the right to freedom of expression as enshrined in Section 16 of the Constitution. So they were saying, this guy just can't come here and say it's defamatory. He has to show that it's untrue. The applicants were therefore asserting that the elements of the law of defamation in South Africa should, in certain circumstances, include the requirement that the defamatory statement be false. They lost the argument and the case. The Constitutional Court said in a unanimous judgment penned by O'Regan that the value of human dignity in our Constitution is not only concerned with an individual's sense of self-worth, but constitutes an affirmation of the worth of human beings in our society. It includes the intrinsic worth of human beings shared by all people. as well as the individual reputation of each person built upon his or her own individual achievements. The value of human dignity in our Constitution therefore values both the personal sense of self-worth as well as the public estimation of the worth or value of the individual. And it should also be noted that there is a close link, says the judge, between human dignity and privacy in our constitutional order. O'Regan then explains that the law of defamation seeks to protect the legitimate interests individuals have in their reputation. To this end, therefore, it is one of the aspects of South African law which supports the protection of the value of dignity. When considering the constitutionality of the law of defamation, the judges emphasize that we need to ask whether an appropriate balance is struck between the protection of freedom of expression on the one hand and the value of human dignity on the other. The court then rejects the argument that is made that you must always prove that you yourself are not guilty of the thing that you are being defamed for. They say sometimes it's not possible to falsify those type of things. Sometimes it's not possible to produce the types of evidence that are required for you to falsify those things. And therefore, it's imperative that the person who is the one making the defamatory statement needs to prove that it's true, not the one who has been defamed having to then go to the court, go through all of the legal costs and all of the other elements that they may require to disprove a lie. It creates a very onerous burden on a person. Every time somebody tells a lie about you, which is defamatory, that you have to go around spending your resources, your time, your energy, trying to disprove to prove the falsity of that particular thing. So they say, no, the common law is fine as it is because it allows for that protection of, the person who's being defamed. And they then say that there are other measures that are present which do balance out the concerns which are being raised by the media houses. For instance, the fact that they can sometimes make the argument that they made a particular publication in the public interest. But they reject the idea that you are the one who has to prove that they are lying about you. So Nhlamulo didn't actually have to go to Lancet Labs and get a test, etc., etc. The burden to prove truthfulness does not rest with Nhlamulo. He didn't need to do that, right? This could have been something that he did to mitigate his risks as someone who's a member of parliament, sitting on committees, doing important work, his risk to his organization, MK Party, where he's apparently one of the people who is a front runner for the replacement of Floyd Shivambu. So perhaps he thought it's important for himself to do that and clear his name in the public, even if he doesn't have a legal obligation to do so in a defamatory action. There are defenses which are available when someone has accused you of potentially making a defamatory statement. The first is truth. If the defendant can prove that the statement is substantially true and in the public interest, fine. Public interest, even if it's not entirely true. If you can prove that the statement was made in the public interest, then you may be also able to escape a defamatory consequence, right? But under this defense, the defendant has to argue that they have a legal, moral, or social duty in making the defamatory assertions to another person who has a corresponding duty or interest to learn the assertions. Right? The legal duty is easiest to establish. If the law states, a statute or whatever states that you have this particular duty to inform the public or XYZ about something, then clear. The social and moral duty, however, must be ascertained objectively on the reasonable person test. Right? And that's quite an elaborate test that we sometimes use in the legal system to see if a decision was made reasonably. Right? If it is proved that both parties had a corresponding duty of interest, then the defendant must further prove that the defamatory assertions were relevant or reasonably connected with the discharge and the furtherance of the interest. So you don't just prove that you have a duty of interest, you also have to prove that they were reasonably connected with the discharge and the furtherance of that interest. And you must recognize the public interest protection is provisional and incomplete. The plaintiff, the person who's accusing you of defamation, may still show that the defendant exceeded the limits of the privilege because he acted with an improper motive. He acted with malice. The question could arise, did Floyd Shivambu act with malice towards Nhlamulo when he did the ENCA interview? That could be assessed on a variety of factors. So you need to be aware that that argument in and of itself, that, you did this in the public interest, has constraints, right? There are various privileges that someone can also claim: media privileges, political privileges for making particular statement. For instance, members of parliament have a lot of free speech privileges that other people do not have when they're on the parliamentary floor saying a variety of things. Then there's the argument that it was fair comment, right? It must be an honest opinion based on true facts. With this one, it must be a comment and not an assertion of an independent fact. That comment must be fair. The facts on which the comment is based must be completely true. And the facts that are actually referred to must be in the public interest. Now, I want to remind you, as I conclude, that there was a case also similar to this. Do you remember the Bonang Mateba matter? A podcaster said rather nonchalantly and recklessly that she was consuming substances of the baby powder aesthetic. And that podcaster, Ria Mohwapane, I think his name is, he got a letter from Bonang Mateba's lawyers. And this is some of what the letter said. On Sunday, 9th of May, 2021, you falsely and unlawfully accused Bonang Mateba in a widely published video of, inter alia, having introduced Kenan Jared Forbes to cocaine. In the context of what was being discussed in the video clip, this defamatory allegation was exacerbated by the shocking insinuation that the death of AKA's girlfriend, Anele Tembe, was due to AKA's alleged use of cocaine. The allegations were defamatory, hurtful, and were deliberately intended to humiliate my client and undermine her reputation. The allegations are also, to your knowledge, false. Your false utterances are compounded by the fact that at the time of making them on a public platform, you knew full well that these utterances would be widely viewed given my client's high public profile. That's what the letter that the young man got. They told him, retract. And he was like, and easy to the retraction. Tell her what you must. And they went to the court, and the young man ended up having to pay a large amount of money to Bonang for those defamatory statements. So at this particular point, if Shivambu is like, no, I'm not retracting my Ibuyele defamation case, he may find himself in a situation where he has to pay a lot of money. So I hope that this episode has helped you understand dilict. It's helped you understand defamation. It's helped you understand when you cannot make a particular statement and what type of constraints you may face. South Africa is a movie. We live in a drama, a series. Every day, you'll be shocked by something new. There's an episode I'm going to make. It's coming on this deputy minister who was fired from the cabinet. Apparently, there's a deputy minister who's been told he needs to go because he was doing things in Washington. I'm going to do a full episode on that, so watch out for that. That's the next episode. See you in the next one. The movie continues. This right here is just an intermission till the next episode.